Flanders v. Goodfellow. Go ahead, counsel.
Good morning, Your Honors. Matt Kaiser and Dwayne Schoonmaker of William Mattar PC on behalf of the appellant Rebecca Flanders. It's an immense honor to appear before this court this morning. I would like to reserve 3 minutes for rebuttal.
Yes.
Thank you, Judge. We raised two main points in our principal brief. I'd like to begin my argument this morning by focusing on the first point, which is the strict liability claim. The Appellate Division erred on the law when it held, in effect, that a domestic animal owner's notice of vicious propensities must be actual in nature as opposed to constructive. Long-standing precedent from this court allows the fact finder to infer notice based on the circumstances, including the duration, frequency, and conspicuousness of the animal's menacing and vicious behavior.
So what specifically do you argue here gives rise to constructive notice?
We have in this case conspicuous behavior on 288 occasions over a 3-year period.
But what about, I thought that the owner testified that in deposition that he had not seen this behavior by the dogs. I assume you're referring to the postal workers' statements, is that right?
Well, yes, I'm referring to Eugene Gregorovich's and
Right.
Brian Harp's statements, correct.
Right. But what do we make of the fact that, I believe, correct me if I'm wrong, that the owner said that he had not witnessed this himself?
Right, and that was Stephen Goodfellow's testimony. However, if
And that's uncontroversial, right?
that Stephen Goodfellow testified that
His
he,
statement that he'd never seen the dog exhibit any of these aggressive behaviors is not controverted in the record.
well, what we do have is we have admissions from the defendants that this dog, which is a 75-pound dog that can stand 5 foot on its hind legs, was something less than a gentle giant before this incident.
That's what the postal workers saw.
No, Your Honor, that's actually coming from Michelle Goodfellow's Facebook post. It's a
Well,
party
wait.
admission.
What specifically are you referring to? She says he's not a gentle giant?
After the training by Gregory Gorman in August, a couple months before this incident, there was a Facebook post to the effect of, we finally have a gentle giant, or something along those lines. The inference being, this dog was something less than a gentle giant before the training. And we also have an awareness of the need to confine and restrain this dog.
I'm not sure I read the statement as you suggest. I mean, I think this is Michelle Goodfellow's statement that you're referencing, is that right?
Correct.
Okay, so why should we read that as her saying that we kept people out of the house so that they didn't have access to the dog, as opposed to saying, we don't let strangers in our house because we choose not to do that, and therefore the dog has not had access to strangers?
Right, and so that's at pages 209 through 210 of the record, where she says pretty much that. She says that unfamiliar people would not have access to this dog, unfamiliar people.
That might be because they choose, for whatever reasons, not to have strangers in their home, perhaps for reasons that have nothing to do with the dog.
Well, actually, she says around the same point in her testimony that if it was someone familiar, the dog would jump in a friendly way, you know, in sort of a welcoming way. But she testified very clearly that this dog was kept away from unfamiliar people. And I think if you couple that with her statement.
Well, kept away maybe is where I'm not sure that the testimony is quite so clear. Didn't have exposure to other strangers. I think that's what she's saying. But why should we read it that she was deliberately keeping the dog away from strangers?
Because she said that they took the precaution of separating this dog from unfamiliar people. This dog, which she said in a Facebook post, was something less than a gentle giant. The opposite of gentle is rough. A big, rough dog being kept away from people who are unfamiliar.
Why isn't this just a credibility issue?
It is, Your Honor. Exactly. It is a credibility issue.
They've said certain things that the trier of fact might infer exactly what you're trying to infer.
I agree with that, Your Honor. In fact, I would refer this court to its decision in Basie v. Gonzalez in 2002. It was a reversal of a Second Department decision, which was a 2-3 decision at the Second Department. And if you look at the evidence that the plaintiff submitted in Basie and compare it to what Rebecca Flanders submitted in this case, Rebecca Flanders' evidence was much more factually explicit, much more robust. The Basie...
But, counsel, you're not suggesting you would have a credibility issue because the jury could choose not to believe someone, right? If this person came in and said, I never heard anything about this dog was so gentle, and you didn't have any evidence on the other side, it isn't a credibility issue, right?
No,
I mean, it doesn't go to the jury and they cannot believe that person.
Well,
It's not a credibility issue, right?
I think if the testimony is viewed in the context of other evidence, including in this case, where we've got 288 instances over a 3-year period, it does become a credibility issue.
Right, but you need some, and that's the issue here, right? Is there enough proof on that side to create this credibility issue? Not that a jury can choose not to believe somebody when they say something.
Right, I mean, I think what it comes down to is the record and the record evidence in its totality creates a situation where a fact finder could connect the dots and say, a reasonably prudent landowner would know what happens 6 to 8 times per month when they receive packages at the front door.
Do you think that you could, if the case were to proceed, could you lose on strict liability but prevail on negligence if a negligence claim were available?
Yes, Your Honor, yes.
And how would that happen?
That would happen because the negligence cause of action is sort of it would apply if the fact finder were to find that this dog was not abnormally dangerous and that the defendants did not have actual constructive notice of the abnormally dangerous nature of the dog. So it's a fallback.
But then what would the facts be that would give rise to negligence liability and not strict
Right.
liability?
And so it's a great question. And so the issue is, strict liability is premised on what the owner knows about the dog. There's no consideration of what's going around, any of the
So
circumstances.
what would the negligent conduct be here, given the allegations that you've presented?
The negligent conduct here would be failing to restrain a dog when you know the dog is a big dog, a rough dog, who is previously restrained and
So you could lose on constructive notice and therefore strict liability, but you think there would still be a path to prevail on a negligence claim if it was available?
And the line of reasoning would be, okay, we're going to fully credit the defendant's testimony, that this dog was an angel, this dog had no problems before this incident, fully crediting that testimony. You did send the dog away for all...
Aren't you fully crediting that is what that was their view of the dog, not the actual conduct of the dog?
I'm just saying hypothetically, if a fact finder were to fully credit the defendant's testimony and say, this dog was not abnormally dangerous, this was a normal dog, the fact finder could also find, under this court's precedent, which existed for 140 years and which finds its foundation in the English common law in the 1670s, that reasonable care could have prevented this foreseeable injury.
Could you have it the other way? Could you have a finding of negligence? Could you have a finding of strict liability but not negligence?
Yes, absolutely, Your Honor.
How so?
Well, because the strict liability more or less nullifies the negligence. If you are strictly liable, then no matter
Right,
what
but
degree
let's
of care...
say you find strict liability in a case. Could you ever not find negligence?
Well, I would say, and I think it makes a good point, because the strict liability cause of action clearly says, no matter how much care you exercise, you're liable. You could, utmost care. You could be policing the dog, hovering over the dog at all times, make sure it doesn't hurt anyone. Once you know you have an abnormally dangerous dog, it's a public nuisance, and if it hurts someone, you're responsible. So once you have strict liability, negligence is out the door.
Right.
Can I
so-
just go back
And
to,
that's, just to clarify, at trial, not at the summary judgment stage, because we're talking about inferences and findings of fact.
My question really is going to, if we were to overrule Bard, right, and if we were going on a negligence standard, why would we keep strict liability?
It serves two distinct public policy purposes. The strict liability rule is based on the premise that you're serving no salutary public purpose to have an abnormally dangerous dog. It's a public nuisance.
But now we're all in a comparative negligence world, right? That's what you're asking for. So why wouldn't it just be a comparative negligence calculation? I mean, you could be negligent in approaching someone's vicious dog, right? Big sign, vicious dog. Why aren't we just in a pure comparative negligence world at this point if we get rid of Bard?
I think that for CPLR 1411, the comparative negligence statute could apply very, very easily if Bard were overruled. I think that would be...
Why wouldn't it just apply to any dog issue? Your dog bite, you're injured by a dog, Okay, let's see who's negligent, how much. Dog has vicious propensities, goes into the calculation. You approach a dog with vicious propensities in a way you shouldn't, goes into the calculation. Why isn't that the world we live in post-Bard?
So, because under Bard, we have this sort of strange situation where dog owners own no duty of care
Well,
whatsoever.
let's say we get rid of Bard. That's what you're asking for, right? No more Bard. Why aren't we in a negligence world with comparative negligence for everyone?
I think that's very workable.
Well, my understanding is that the restatement as it currently exists has separate actions. I think it's 509 for strict liability and 518 for negligence. And it does seem to me, to the point I take Judge Garcia to be making, that there's a fair amount of overlap, and that's especially so because the comments to 518 task an owner with knowledge of the normal characteristics of the breed and so forth.
Correct.
But it looks to me like the restatement at least sees a world in which it's useful to have two separate causes of action. Do you know what other courts have done in that regard and whether or not they have, for example, found, you explained how you might find negligence but not strict liability. It goes to whether you have actual constructive notice of the vicious propensities, right? But what about the other way around? Do you know if other states have found strict liability but not negligence, or have they just not proceeded to the negligence claim?
Well, virtually every other state has recognized that these are dual causes of action that can be parallel.
But in actual cases, right, I'm wondering if you know how that has played out. So when someone brings both a strict liability and a negligence claim, and the court finds that strict liability lies because the owner had actual constructive notice of the vicious propensities, what happens to the negligence claim? Does it still get considered? Could you find strict liability but not find negligence? Does it matter?
Yes. And that goes back to kind of what the point I was making with Judge Garcia, is that basically strict liability, if a jury were to find strict liability, negligence is irrelevant.
Because liability exists in any event and you just don't need to proceed to consider it, is that why?
Exactly.
And in that case, there's no apportionment of liability. No
Correct.
apportionment based on culpability of either party.
Correct. Yes, Your Honor.
Are these then, in your view, alternative bases for liability? That is to say, if there's strict liability, you don't even move on to the negligence claim?
Correct. At
You
trial.
only move on to the negligence claim if the trier of fact decides
Right.
against the plaintiff on strict liability.
Exactly. Once the trier of fact determines that there's strict liability, as was noted by this court and as was noted by the Second Department in Colarusso v. Dunn, it's irrelevant. Comparative fault is irrelevant, and what the defendant did or didn't do is out the window because the wrongful act is the keeping. The wrongful act is the keeping of the animal, nothing with respect to the animal vis-a-vis society. And so, and I would just refer this court, now that we're talking about negligence, it really creates a situation where every negligence analysis in New York State begins with the question, what was the instrumentality of harm? If it's a domestic animal and it didn't wander from a farm, the Hastings exception from 2012, go no further. You can act as abjectly unreasonable as you want. And I see that my time is up, so I will sit down.
Thank you.
Before I begin my remarks and address this case, I want to take the opportunity to thank this court and counsel for allowing me the honor of seeing my son-in-law promoted to colonel. With that, Michael Perley from Hurwitz Fine, we are appellate counsel for the Goodfellows. First of all, I want to address the fact that this case, two lower courts have decided that the strict liability cause of action doesn't lie because there's no constructive notice. And it is clear on this record.
Why isn't there a question of fact?
Because, Your Honor, the affidavits, for whatever they might say, are an attempt to backfill constructive notice. They have to be measured in regard to what the responsibility of a postal employee is during the time that they're making deliveries. And if they had actually seen and identified a dangerous animal. They owed it to their employer and their colleagues and their coworkers.
Doesn't that go to
file that
credibility?
notice.
I mean, isn't that a question of whether or not a fact finder should believe the statements in those affidavits?
Well-
And thus, maybe, deepens the question of fact, but doesn't eliminate it?
I don't believe it raises enough issues, Your Honor, to create a question of fact.
But aren't those really, to repeat the question, credibility issues? You're saying because they didn't report it to anyone else, they didn't tell a supervisor or give a notice to the property owner that, a vicious dog notice or whatever they call it, that somehow it's incredible as a matter of law. Isn't that really what you're just saying?
They had, not as a matter of law, but they have to be looked at with a jaundiced eye, but they don't fulfill their purpose.
But John Destai, I think, is really about evaluating credibility.
They don't fulfill that may well be, if they fulfilled their purpose. They did not
And why
fulfill
do
their
they not
purpose of
do that?
imputing constructive notice onto the dog owner.
Why not?
Because they never told him. All they did is observe.
But if you credit the statements in the affidavits, right, and I understand that you would surely argue that you shouldn't for some of the reasons you just identified, but if you credit them, the dog was exceedingly aggressive with strangers, and, it stands to reason that perhaps a fact finder could conclude that if those statements are taken as true, that there's a very, very high likelihood that the owners would have witnessed that behavior at some other point in time and therefore be willing to decide there was constructive notice.
Your Honor, the uncontroverted testimony of our clients observing the dog doesn't justify that. Right? They know what they know. They know what they have seen. Now, I could see constructive notice had somehow or other those folks who apparently were so worried that they didn't bother to tell their co-employees.
Well, let me
told the
change
Goodfellows.
the facts. And suppose the postal workers had, as was required by postal regulations, reported to the supervisors, hey, this dog is throwing itself against the window every time we come. That would have created a question of fact despite the affidavits of the owners saying we never saw this?
I'm not convinced that it gets there either, Judge.
Well, so then
But
the
it-
fact
it-
that they signed doesn't really matter, that they didn't report, I mean.
What it shows is a lack of concern on their part for what they observed,
How's
in my
that?
view.
How is that?
Well, if you were really concerned about that, and you knew that you weren't the only postal employee or mail carrier on this route, you would tell your colleagues.
Okay, I think you've gotten questions from several judges that this may be not perfect compliance with regulations, but how does that affect the truth of the matter asserted, which is simply that they've observed this dog on multiple occasions, hundreds of occasions, if you believe the affidavits, exhibit vicious behaviors. And that may be imputable to the property owner.
Your Honor, I can't cross-examine an affidavit, so. it
No, but a
would-
fact finder can.
Potentially, but
But
it's still.
let me just, having a little bit of confusion as to why this argument about that doesn't raise a question of fact, given the standard, of course, benefits the non-movement, not the movement. But they don't just say the dog is barking and looks vicious. They're saying it slams itself against the window, bites the window, leaves saliva on the window. Right? Doesn't that, at a minimum, get you to a question of fact, of constructive notice, even if the homeowners were not home for any of this? Grant that to you again. I think the standard may work against you on that, but let's go with that for one moment. You walk in, you've got dog saliva all over the window
Well,
on
there
numerous
wa-
occasions?
There was no testimony from our clients of this type of activity, and there was
I
no
know,
basis
but
for them to
Mr.
conclude that.
Curley, there may not have been that testimony from your clients,
Right.
but it was offered through the affidavits that conduct occurred. And again, as to my colleagues asking, a question of fact in the very least being arisen, whether or not they reported it to the postal authorities.
Your Honor,
Why isn't there a question of fact then?
because the knowledge in our view, the knowledge isn't imputed to the Goodfellows, and 2 courts have already agreed with us. And I know that this court makes its own decisions, but once again, this is after the fact. It doesn't impute knowledge before the incident.
Can I
Speaking of-
ask you,
Sorry,
I'm
go ahead.
sorry, if we could just move on from this line of
That's
questioning?
where I was going to. Go
Yeah,
right
and
ahead.
just, what's your strongest argument for us retaining Bard?
The strongest argument for retaining Bard, actually, Your Honor, is that I think Bard is a little unusual in one sense, that if it were going to be reconsidered, it would only be reconsidered in the context of farm animals. Dogs are treated differently in New York than domestic animals. You read the Agricultural and Markets Law, dogs are, I think, subsection 5, and domestic animals, farm animals are 7, and they are treated differently in the Ag and Markets Law because they are socialized to human beings. So,
But why does that mean that a negligence cause of action shouldn't lie?
well, Your Honor, I think there's a number of reasons, and I would appreciate the opportunity to articulate them. First of all, interactions with dogs in the street, on a leash, in a home, wherever, are dynamic events. They are events where there are moving people. There's the dog owner, the dog, and the
But
unfortunate
isn't
individual.
that true? It seems to me that New York stands alone in having adopted this rule. And there are surely significant concerns of stare decisis, but if we focus for a minute on the merits of the rule, I would have guessed that if the nature of the interaction between humans and dogs merited a rule that's different from traditional negligence principles, so different that you can't have a negligence claim at all, that some of the other 49 states would have identified that concern and perhaps reached the same conclusion. So what should we make of that?
Your Honor, it might be right for other states. I submit that it's not right for New York, based upon its jurisprudence, and thank you for anticipating part of my argument, which is this has been the longstanding rule in New York.
Well,
and-
since
and
2000
it has
and,
worked well.
I think BARD is about 20 years ago, right? So-
When you say it's worked well,
Yeah.
what about in instances where there is conduct that's put in motion by the owner and a person is seriously injured with no means of recovery? Why is that working well?
Well, perhaps you're thinking of the one case where maybe the owner threw the ball, and maybe that's on the owner, not on the dog.
Well, we're suing, they were suing
sue
the
the
owner,
owner.
not the
Suing
dog.
the owner. Well, you
Let-
could look at
Let me
that
ask you about
case
your distinction
if-
between farm animals and domestic animals, and the point that the domestic animals are socialized by us and so on. Why doesn't that cut the other way? That is, for animals that we care for and we train and we keep in our homes, we actually have some ability to control them and therefore should be responsible in negligence, plain negligence for our actions. Whereas farm animals and so on we don't have that kind of relationship with or responsibility for, are less out of our control, and we should therefore be less responsible for them,
Well, Your Honor, negligence is defined by duty,
right?
right? So.
Might we have a greater duty for animals that we keep in our homes and train and domesticate and socialize than ones that we don't?
While we can look at plaintiff's recovery, every dog owner needs to know, or should know, the way every driver of an automobile knows, what their duty is, especially in dynamic situations. We have 4 or 5 articles in the Vehicle and Traffic Law to tell drivers how they should act.
Well, presumably, if we were to change the rule, then there would be that notice. I guess here's what I'm struggling with, and maybe you can help me. It seems to me that even the most well-trained dog, inevitably, it's still an animal and it has instincts and may behave in ways that cause harm to other people. And under BARD, the person that bears the cost of that, if the owner has not acted with due care, assuming the owner doesn't know about vicious propensities, so there's no strict liability, is the victim. And usually, and I think in every other circumstance, right, we don't require the victim to bear the cost when someone acts without due care. So why should it be different for domestic pets, then everything else, I think, that comes into play in our interactions with other people.
Well, Your Honor, I would like to start that answer by saying Collier, at some level, addresses that when it talks about proclivities of dogs that are not necessarily inherently dangerous. Second of all, Your Honor, it's where you draw the line. I mean, if a dog is on a 15-foot leash and there's an unfortunate interaction, should it have been on a 10-foot leash?
Well, but wouldn't that be something that a jury would sort out? And presumably you would have comparative fault as well. So, for example, when someone comes up to a dog unsolicited and is nipped as a result, perhaps that would be taken into account. But I guess I'm still grappling with the question of why dogs should be treated differently than everything else.
Well, Your Honor.
And maybe cats too, I guess they would qualify, but.
As you're talking about a bite, but there are other interactions where a dog could trip somebody on a leash or
Also,
whatever.
there are thousands of potential interactions. I think what's being suggested to you is we've had negligence, due care exercised by a reasonable person around in New York for a couple hundred years now in a lot of different areas. Why can't we just apply the same standard we apply to everyone else and say, under these circumstances, was this what a reasonable person would do with their domestic animal? Same way we do it for cars and our premises and everything else. New Yorkers understand the negligence concept.
Well, I'm glad you brought up cars again, Your Honor, because we've defined those rules. What does the dog owner know what his or her duty is to the general public? The reason that the system we have now works is the notice defines the duty.
There are rules like the vehicle rules that apply to dogs. For example, you have to have a license for your dog in New York City. If you're going to walk your dog in a park, it has to be on a leash, except certain areas that are designated as dog runs or a central park before 9 in the morning. There are rules like the vehicle rules.
Well, statewide, Your Honor, there are 2 rules. You have to register the dog and get a rabies shot, statewide.
Yeah.
And we're not.
But localities can create their own rules.
Absolutely, and, it's clear that they can. And that's fine for certain areas, larger cities. New York is a classic example. What about everywhere else, where the rule is you have to register your dog and get a rabies shot? That's your duty.
What about everywhere else now? There's a proliferation of animals being in places where non-pet owners would not necessarily expect them to be. Why wouldn't we want people to have recourse if they are injured because of an irresponsible owner?
The way you pose the question, Your Honor, it's hard to argue with it. But an individual has a dog on a leash, and that dog on the leash runs to a point where somebody trips over it. That is an irresponsible
We're
owner.
talking about vicious
No.
propensities. We're
long?
talking about vicious propensities, but under your
Yeah.
rule, as you continue to apply Bard, because we're talking about Bard, on Monday, the dog can go bite someone. Okay? No notice of vicious propensities, they're not liable. On Tuesday, the dog bites someone else. Now they're liable. Where's the logic in that?
The logic in that is that the owner of the dog.
If they were held liable the first time, perhaps they would have taken appropriate care the second time.
Well, Your Honor, perhaps, but in that scenario where there is such a short period of time,
Well, you're trying to incentivize, right? You're trying to incentivize people to take appropriate care, be cautious.
I think one improper action by a dog creates sufficient incentive, or it should, in any reasonable person. And if a person
A
has
reasonable
no,
person wouldn't have allowed for the first time.
if a person had no basis on which to understand that the dog would act in that fashion.
Well, what about just leaving your dog outside while you go inside of the store and it harms someone? You loosely tie it to something, and it's a huge dog, and the dog gets loose because he's not properly being supervised and he bites someone. Because you didn't know he didn't have vicious propensities and you left him unattended, that is fair that the victim of the bite should suffer without recourse? Why?
The way you pose the question, Your Honor, it's very difficult to answer because I don't know what the other person did. And
The other person walked by, this dog that appeared to be tied, was not tied, and chomped on the passerby's leg because he was left unattended, not secured or supervised. Why is it that the person who is bitten would have no recourse? Because you didn't know your dog had vicious propensity.
I think you can answer that question more broadly, which is if the dog wasn't properly tied, then it was the responsibility of the owner. Dog wouldn't even have to bite somebody, could trip somebody and hurt them at that point. But
But
because
still,
it
there's no
wasn't properly
recovery
controlled.
because there's no vicious propensities, correct?
Well, right. Well, no, there could be liability on the owner because if the dog were improperly leashed and got loose and did something,
No,
then there would
counsel,
be an
but
opportunity.
this hypothetical is not a trip and fall. It's a dog bite hypothetical. So, I mean, I think you have to admit, under current standards, there would be no liability in that situation, don't you?
For the dog bite,
For the dog bite.
you're right, Your Honor.
Is there liability if someone trips over the dog now?
There
under
could
our
be.
rules? I thought we said there isn't.
What about
Well,
door?
Yeah.
Well, there,
No bite involves a door.
I think it all depends on circumstances, Your Honor. It all depends on circumstances, but I do want to address one other issue just briefly. Under the restatement for the negligence cause of action, the restatement requires individuals to know the propensities of the animal that they own. We have no provision in New York to do that, and that is going to, if that were adopted, that would inflict on residents of New York an incredible immediate burden that they did not anticipate.
Thank you.
Thank you.
Counsel, could I pick up on something Judge Halligan asked? If we are in a post-barred world, and I have a cat, and I'm not saying if I have a cat or not, but if I had a cat and it got out and it ran across the street and a car swerves and gets in an accident, am I liable?
I think that there are cases which say that violation of a leash law, which I guess it would depend on your particular locality and whether it includes cats and whether cats are required to be leashed. I don't
There's
think
no
they generally.
rules. Where, as far as I know, there's no rules. I have a door, the cat goes out, cat goes where it wants, right? So now my cat runs, if I had one, in front of a car. What happens?
Well, I think we'd have to have some more information about, because it all stems from having notice. There is a notice element to negligence. It's
But
different.
I know the cat goes out, I know it leaves the yard. What else do I need to know?
We need to know, has this cat done that before? Has this cat done that before? Is there a municipal ordinance that would require the cat to be contained?
So let's say there isn't. There's no ordinance that requires restraint of cat.
I would say no then, Your Honor. I would say, Young v. Wyman, I think, speaks to that situation where we've got a dog in the road. This is 1990. This court analyzed that negligence claim and said, really relying on the restatement, one of the comments in the restatement saying that certain animals are expected to romp freely. I would say no under those facts, Your Honor.
Wouldn't it be a question, as it would with any negligence case, of whether or not under those circumstances due care was being exercised?
Yeah, yes, Your Honor, and this is not
Are there really broad, are there very specific rules as opposed to fact, case-by-case consideration of the facts?
And in writing our brief, we were looking at other jurisdictions to try to illustrate how workable a companion negligence claim would be. And we found that actually the appellate courts of this state have some of the most robust, the first department and second department.
So Judge Halligan referred to stare decisis. So let's just stay for one moment on that issue. What would be the basis now, other than perhaps there are, at a minimum, 4 members of the court who think that barred was, that's not a good rule, it was wrongly decided? What other grounds would we have to now decide to overrule barred? Or
Right,
to
and
no
this-
longer apply that rule.
Right, and I know that opposing counsel mentioned that the BARD is a long-standing rule. I would ask the court to expand the temporal scope of the case law to look at where BARD is, kind of in this timeline of, we got an ungovernable horse in Lincoln's Inn in England in 1674, all the way to Young v. Wyman in 1990, and then all of a sudden, this respectfully aberration that is BARD, where we're going to stop following this line of cases.
So your position is that that it was, it's an aberration, was wrongly decided to begin with, and that is something that is not just a decision now because, again, at least 4 members, perhaps more, of the court think it was wrongly decided.
Right, Your Honor, and I'd refer to People v. Hobson, where this court said that if the precedent is of an uncertain root and in collision with prior doctrine, much more embracing in scope, which we clearly have here, this is well settled, and this was in the common law for centuries.
Cut against that argument in a way if we've made a fairly recent decision to do something differently? Is it cut against your argument that we would revisit it so quickly?
Well, my response there, Your Honor, would be that the plaintiffs who came before this court were not asking this court to not give BARD stare decisis treatment. They were seeking to say, BARD doesn't reach our case. BARD is outside the scope of our case, or we want an exception. Plaintiffs shouldn't vie for exceptions. They should just demonstrate.
But if at one point there was a court that said, well, we understand there are some jurisdictions, or perhaps the majority of jurisdictions, don't like this rule, but we think there's something good to this because it's strict liability. It ensures that the owner will always be responsible. Here's the one caveat: you've got to have notice. So now some other members of the court think, well, I wouldn't have picked that rule, and now I've got the numbers. I've got the majority. That's not usually how stare decisis works.
Well,
or how we end up overruling, right?
Well, and the mere fact that BARD is precedent doesn't mean that it deserves stare decisis treatment. Cases need to earn stare decisis treatment by upholding
generally
the
we
object
do.
and purpose of the law.
Generally, we do accord cases stare decisis treatment, and you need a pretty good reason, I think our cases say, including Hobson, to overrule a prior case.
Yes.
So you've said prior doctrine is otherwise.
Mm-hmm.
You clearly think it's incorrect, but what other reasons are there for us to take that step?
Well, it's unfair because in this case, for instance, just to kind of go back to the facts of this case, there should be a public policy in favor of people acting reasonably at all times, regardless of the instrumentality of harm and regardless of the precise manner in which the harm materializes. Here, very slight, minimal degree of care would have prevented Rebecca Flanders from being maimed. Close the door behind you. Very slight degree of care. Our strict liability regimen, it does not focus on what people do. It focuses on what they know, and that is not a fair state of the law.
Thank you.
Thank you, Judge.